I represent one of the largest Jewish communities in the country to which I also belong. Over the last decade of the Liberal government, hate crimes against the Jewish community have more than quadrupled. I believe that your appearance today is evidence of your government's failure to protect the Jewish community. To add betrayal to injury, the Prime Minister rewarded the worst terrorist attack in our lifetime with the recognition of a terrorist state. So please don't pretend that you're doing us any favors. But what I am seeing is that unless Bill C-9 is amended, it will criminalize and prosecute speech that isn't criminal right now. So let's get into it. For 35 years, we used the Supreme Court definition of hatred from a case named Kijkstra. It is an emotion of intense and extreme nature that is clearly associated with vilification and detestation. You say that you're trying to codify the Supreme Court jurisprudence, but your definition that you propose in Bill C-9 is the emotion that involves detestation or vilification and that is stronger than disdain or dislike. You removed the words intense and extreme nature from the Supreme Court definition. Why are you trying to lower the bar to charge and convict people of hate speech? Is it to criminalize speech that liberals don't like?
No, and I'm just curious, in the preamble to your question, you indicated that there is additional hate speech that may not be criminal. And I'm curious, is there certain examples of hate speech that you think should not be criminal?
No, I'm saying that we have a clear definition of hate speech from the Supreme Court, definition that your government is trying to dilute through Bill C-9. Why are you diluting this definition by eliminating the words of an extreme and intense nature?
So when I review the definition of hatred, not just in the Kijkstra but the Whatcott decision as well, it's clear to me that vilification and detestation are extreme manifestations. To the extent that you have a different interpretation, know that the intent of the legislation was in fact to codify not only those specific sentences in the decisions, but the different factors that the courts would have used over the years to identify. Should the committee feel that the legislation would benefit from a different reflection of the test that the Supreme Court has laid out, do know that that would not be a deal breaker for me, particularly if it would earn multi-partisan support and send a signal to Canadians that all parliamentarians want to combat hate in their communities. This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement.
It is doing exactly that. And in fact, the court in Whatcott has referred and reaffirmed the definition of Kijkstra. I'm scared that you're going to use your proposed definition against Canadians and against members of the Jewish community. Your proposed definition is so broad, ill-considered by the courts, that it's probably unconstitutional. But should Canadians expect, like in the videos we're seeing out of the UK, that police are going to be knocking on their doors in the middle of the night for a Facebook comment?
Absolutely not, and I think the suggestion is patently far-fetched on the face of it.
All right. Bill C-9 will remove the requirement for the consent for the Attorney General to prosecute hate speech. The previous Attorney General said that the consent is a required safeguard. I heard your position during debate that in the future you may have a political Attorney General who will withhold consent to lay hate charges. But if the Attorney General can be political, then certainly a Crown Attorney can also be political, and a police force or a police officer can be political, and their judgment could be clouded politically, and they can potentially bring hate charges when it isn't appropriate and ruin someone's life. Have you considered that?
I've considered many aspects of this, and I like to start with the problem that we're trying to solve. We heard loud and clear from affected communities that charges were not being laid and justice was not being served. Stakeholders and, in fact, the Justice Committee had, including multi-partisan support, including your own party, have supported this particular change. I also hold the view, in addition to the argument that you've put in place, that with the extensive body of case law that has emerged over decades that has been informed the actions of law enforcement, the additional safeguard that the AG consent once provided is not as necessary today as it would have been back then. Wanted to solve the problem to ensure it was easier to lay charges where law enforcement can apply the law independently when they see hate in their communities in an effort to stamp it out everywhere.
It will be especially easier with you diluting the definition of hatred, but what's even more scary is that private prosecutions will also be exempt from Attorney General consent. Now, yes, the Crown may withdraw or stay charges, but the complainant could appeal either the Justice of the Peace or the Crown's decision to stay the charges and drag an innocent person into divisional court on judicial review. Do you really fail to see how allowing private prosecutions for hate offences without the Attorney General's consent could be weaponized against innocent Canadians, including members of the Jewish community?
Mr. Baber, the time's up. Perhaps one of your members can pick that question up later.
Minister, do you really fail to see how allowing private prosecutions for hate offences without the consent of the Attorney General could not be weaponized against innocent Canadians by vexatious litigants or political opponents?
I have a lot of faith in the ability of courts to police frivolous and vexatious litigation. You see the opportunity for courts to screen out those kinds of complaints with great frequency. If the committee wishes to take evidence from experts in the space to understand the protections that do exist and where it can be improved, do know that I don't come into this with some preordained outcome. I believe in the work of Parliament. I believe in the ability to take evidence from witnesses and to propose amendments, and would consider each of them in good faith should you wish to move forward with some.
I also have a lot of faith in the courts. The problem is that by the time you get through due process, you may be taken through litigation, your reputation may be ruined, you may incur a lot of legal fees. So this is a major concern for myself. With respect to the new hate offense, the new criminal hate offense can be laid on top of any offense under any federal law. Is that correct? Yes or no?
Yes.
And so an offense under the Elections Act or an offense under the Canada Labour Code may attract criminal prosecution. Someone, for instance, could be charged criminally for non-payment of wages under the Canada Labour Code. Isn't that correct?
I have a hard time understanding how non-payment of wage, if there's a motivation of hatred towards another individual and you commit a crime against that individual because of who they are, it could attach to virtually any charge. The likelihood it would come up in that set of circumstances, I think, would be quite small.
You're basically talking about tacking on criminal charges on what is otherwise civil, non-criminal behavior. This is very concerning. You may have unintended consequences when you combine that with dilution of the definition of hatred, as you're doing, and the possibility for private prosecutions without Attorney General consent. This is a very concerning piece of legislation, Minister. Thank you.